Hello and welcome to everyone who has joined us, and a particularly warm welcome to those of you who have joined from other time zones. I know we have people who signed up to this event from America, from Ukraine, from Cyprus. So welcome to everyone. I'm Dr. Bianca Jackson. I'm a barrister at Coram Chambers, and I practice exclusively in family law. I'm joined today by Sarah Wood-Heath, who's a family law solicitor, and who also practices exclusively in family law, and Barry O'Leary, who is a immigration and nationality solicitor, who practices, as the name suggests, in nationality and immigration. And all of us have a particular expertise in surrogacy and working with intended parents, both in this jurisdiction and internationally as well. So today's talk has been titled Working with British Intended Parents. So really, it's aimed at those of you who are working with British intended parents outside of this jurisdiction. However, for those of you who practice domestic surrogacy or are involved in some way in domestic surrogacy, it's still relevant because the law remains the same, as you'll see, regardless of whether you're in this jurisdiction or otherwise. So just to give you a sense of what we're going to be talking about tonight, I'm going to talk a bit about the UK legal system and attitudes towards surrogacy. So I apologize to any practitioners who are UK based. This will be old hat to you. But for some of our international participants, our legal system can be somewhat confusing and bizarre, frankly. I'm also going to speak about parental orders and the legal definitions of parenthood and why parental orders are important. I'm then going to pass the baton on to Sarah. And Sarah is going to talk about the criteria for parental orders and the court process. And finally, we're going to pass on to Barry, who's going to talk about nationality and immigration around international surrogacy arrangements. Each of us will talk for approximately 20 minutes, and then we're going to have questions at the end, which will be facilitated through the chat function. So if you could just save your questions until then, that would be incredibly helpful. So to start out with me, barristers and solicitors, what is the difference? So it's quite a strange system to our international colleagues because we have a system whereby it is divided between barristers and solicitors. Now, to put it at its simplest, barristers are very much courtroom attorneys. So you'll have noted I'm a barrister, but Barry and Sarah are solicitors. What that means in practice is that Sarah, for example, really does everything. So a client would go to her, the client would say what sort of application she wants to make. So for example, in surrogacy, that would be a parental order. She would be advising the client, producing any documents for the court, any evidence, any statements. And then if it went to court, which it would in an application in respect of surrogacy, she would potentially then instruct counsel like myself to do the courtroom advocacy. So solicitors are part of a firm and they're employed, and barristers tend to be self-employed, and we're instructed by solicitors who are in turn instructed by lay clients. Now, that's very much the traditional difference between them. In practice, you now have solicitors who have rights of advocacy, so they can appear in court in lieu of barristers. And simultaneously, we also have barristers who do what's called direct access, which means that they can do a lot of the things that solicitors can do, but lay clients can go to them directly without the need for a solicitor. So the line between them is getting quite blurred. But traditionally, barristers are involved in the courtroom advocacy and solicitors are more behind the scenes. And so if you had a client who was looking for advice in the UK about surrogacy arrangements, they could either go to Sarah or myself, likewise for whether they're going to do the courtroom advocacy as well. And I should also point out that notwithstanding this picture, we don't wear wigs in family law for the most part. Wig wearing is just for when you appear in the Court of Appeal, or if there's what's known as committal proceedings. It's a certain type of proceedings that has a criminal law aspect, because in criminal law, they still wear wigs and gowns, but we don't tend to. If you think about it, we deal with families and children, and it's a bit more approachable to be dressed, I guess, in a suit than it is to be dressed in a wig and gown. So that's a very basic definition of the difference between solicitors versus barristers. Which takes me to surrogacy in this jurisdiction. So surrogacy in the UK is fundamentally altruistic. Commercial surrogacy is prohibited. However, interestingly, intended parents or surrogates who engage in a surrogacy arrangement are not guilty of an offense. Payments are meant to be for reasonable expenses. So the things that are actually criminalized in practice are to advertise, and that's either if you're advertising yourself as a surrogate or advertising for a surrogate as an intended parent, you're not meant to do that. It's also not permitted for third parties to broker surrogacy arrangements. So for example, if a solicitor put a surrogate mother and intended parents together and drew up an agreement and so on, that would be illegal. And the penalty for doing so is a fine or up to 3 months imprisonment. Now, there are exemptions to that. We have 4 main surrogacy non-governmental organizations that are involved in matching up intended parents to surrogates. So those are COTS, which is short for Childlessness Overcome Through Surrogacy. We have Surrogacy UK, of which I sit on the ethics board. There's Brilliant Beginnings. And then the newest kid on the block is My Surrogacy Journey. So if people want to explore surrogacy domestically, they can go to one of those 4 surrogacy organizations. People also identify possible surrogates by, through friends and family. There's also a lot of finding of surrogates through social media and, for example, closed Facebook groups, but those come with their own dangers. So the question is, given that we have these organizations, well, why do intended parents in this jurisdiction go abroad? Now, one of the main ones is a greater pool of surrogates. So I mentioned those 4 main surrogacy organizations prior. Just to give you an idea, COTS, I know, is closed to applications from new intending parents. Surrogacy UK has a waiting list to join. And that's just to join. That's not even starting the process of surrogacy. That's just have your name down so you can start joining, start attending events with surrogate mothers. Brilliant Beginnings doesn't do it on a waiting list as far as I know, but it's still, they estimate on their website, it's 18 to 24 months. My Surrogacy Journey, I'm not entirely certain statistics, but these are groups that are very oversubscribed at the moment. And the reason for that is that we just don't have as many surrogates available as you potentially do in jurisdictions where commercial surrogacy is promoted and regulated. So that's one of the main reasons, is to be able to identify a surrogate. Another reason that some intended parents will go abroad, additionally to that, is they might want a more streamlined process. So of course, that's not going to be true of all international jurisdictions, but there's certain places, one thinks, for example, of California, where everything is so well regulated that it's made it incredibly easy to engage in a surrogacy journey in a way that is more facile than places where it's unregulated. And then another, of course, big issue for clients is cost. Now, again, that's going to be country dependent. In this jurisdiction, the estimate is if you use a domestic surrogate, it's going to cost you around £30,000 all in. If you go somewhere again, like California, you're looking at 120,000. So you're not going to be traveling there for savings. But then there's other countries you go to where you can get it cheaper than 30,000 in the UK. So some clients do go there for a cost factor. But the most important thing to take away from this talk today, from my point of view and from Sarah's, is the thing that you need to know is that regardless of where the surrogacy arrangement takes place, British intending parents have to apply for a parental order in the UK, even if they're recognized as the legal parents in the jurisdiction in which the arrangement took place. And this, I find, in speaking to clients, is the hardest thing for them to get their heads around, and understandably, because let's say you go somewhere like California, and you can have your name put on the birth certificate. For all intents and purposes, you appear that you're the legal parent of the child, you're the legal parent in that jurisdiction, but that legal parentage doesn't travel with the child. So anyone who engages in surrogacy abroad has to, when they return to this jurisdiction, apply for a parental order. Now, these are our probably most famous intended parents in the UK. So just looking at what is a parental order and why do British intended parents need them? So a parental order does two things. So essentially, it provides the intended parents with legal parenthood and something we call parental responsibility. Now, parental responsibility is all the rights and responsibilities that come with being a parent. So for example, the ability to make decisions about your child's education, their medical treatment, and so on. So they get that, and simultaneously the parental order takes that away, the legal parenthood and parental responsibility, from the surrogate and her husband, wife, or partner, if applicable. Now, the reason that we need that in this jurisdiction is that a child here can only have two legal parents. So more than two people can have parental responsibility, which is what I referred to earlier, but only two legal parents. And the UK has its own specific definitions of what different parents are when assisted reproduction is used. And so that's why we need the parental order to alter those. Now, if we look at the legal definitions of parenthood, the first is the legal mother. So in British law, the legal mother of a child born by way of surrogacy is the person who carries the child. Already you can see the problem with that in surrogacy arrangements. And that's the same no matter whether the child is genetically related to the surrogate or is not genetically related to the surrogate. If donor eggs are used, for example, it doesn't matter. It's the act of carrying the child that defines motherhood. And I should say that's also the same where the mother is a transgender male. We still call transgender men who have children mothers, even though it doesn't match up with the gender, because it's the act of carrying the child. But that's a whole different scenario. That's a talk for a different day. But the person carrying the child, who's the mother, is an irrebuttable presumption. So there's no getting away from that one. Now, a child who's born via surrogacy can also have a second legal parent. Again, you can see the problems already in that if the surrogate mother is married or civilly partnered at the time for treatment, the legal father or second parent of the child will be the person who's married or in a civil partnership with the legal mother. For those of you who potentially don't know, we have marriage and civil partnership for both same-sex and heterosexual couples. But as long as those people, the partner, consented to the treatment, they will be treated as the legal parent. Again, it doesn't matter, well, they wouldn't be genetically related. And so again, you see the problems that can occur for people who are engaged in surrogacy and are not going to be recognized as their child's legal parent, even though they're in the intended parent. Where the surrogate is unmarried or not in a civil partnership, then a legal father or second parent can be designated. So if no one says otherwise, then the intended father can be seen as the legal father, provided that he's also the biological father. If the treatment takes place at a licensed fertility clinic, then the surrogate can appoint the intended mother or the non-biological father as the second parent. But you will still need to apply for a parental order because there's still, of course, the fundamental difficulty of the surrogate mother being identified as the legal mother. Now, sperm and egg donors are not regarded as the legal parents of the child. Again, that should have been quite self-evident from our definitions of children. One thing to note, though, is that we have specific statutory definitions of what constitutes sperm and egg donors. So we've had in this jurisdiction a plethora of cases, for example, where not in a surrogacy context, but people have utilized what they regarded as sperm donors. They used sperm from a friend, but that's not considered a sperm donor. And so then there becomes arguments about legal parenthood. But that, as long as they are sperm donors in the statutory sense, or egg donors in statutory sense, they're not going to be regarded as the parents in any event. So all of those aforementioned definitions that I was talking about apply, as I said, as I alluded to before, regardless of where the surrogacy arrangement takes place. So it doesn't matter what they say in, anywhere from America to Cyprus, we do not regard the intended parents, or especially the intended mother, as the child's mother until such time as a parental order is made, which really shows you how fundamental it is for intended parents in this jurisdiction to apply for parental orders and to get legal advice, not only from where the surrogacy takes place, but also in this jurisdiction as well, which no one likes to hear, because you don't want to have to pay lawyers sort of 2-3 times over once you factor in immigration lawyers as well. But, Sarah and I see often the difficulties that ensue when people don't take early legal advice. And that's when you end up in the high court with high cost cases. So that's very much a whirlwind introduction to how we define legal parenthood in the UK and the importance of the parental order. And I'm now going to pass on to Sarah. Sorry, if I can figure out how to do my screen. There we go. And Sarah is going to talk us through the criteria of parental orders and how you, if you are an international clinic or organization working with British intended parents, or a lawyer working with any really intended parents, can assist clients in identifying the information that they're going to need at the end of the day to apply for that parental order in this jurisdiction. So Sarah, over to you.
Thank you, Bianca. So Bianca's just explained the importance of obtaining a parental order here in the UK, which is the bespoke solution following a surrogacy arrangement. So when intended parents make that application to the courts, what is the court assessing? And what criteria need to be met for the court to then make that order? So the legal provisions and legislation for a parental order are set out under Section 54 and Section 54A of the Human Fertilisation and Embryology Act 2008. So the very first provision contained within this states that the courts can make an order for the child to be treated in law as the child of the applicants if the child has been carried by a woman who isn't the applicants as a result of the placing in her of an embryo or sperm and eggs or her artificial insemination. So to meet that first criteria, there needs to have been a surrogacy arrangement taking place. We then turn to the second requirement, which is that of a biological connection. And the provision states that the gametes of the applicant, or at least one of the applicants, were used to bring about the creation of the embryo. So in other words, in order for a parental order to be made, there must be a genetic connection to one of the applicants. Within a parental order application, the court requires evidence of this, and sometimes that could be a request for a DNA test. But more often than not, certainly in the cases that Bianca and I have worked with, the court has accepted a sworn affidavit from the treating physician who may have undertaken the embryo transfer. So once it is established that the child was carried by a surrogacy arrangement and that one of the applicants is genetically connected to that child, there are then a number of other conditions that then need to be met. So historically, an application for a parental order could only be made by 2 people, but the law changed relatively recently to allow single persons to apply. However, if you are making the application as a couple or as 2 people, then the law still has definitions of what relationship you must be in. And that is set out as a husband and wife, civil partners, or two persons in an enduring relationship. And for the purposes of an enduring relationship, that then falls to the judge to determine on a case-by-case basis for that. Okay, in terms of evidencing that relationship to the court, typically a marriage certificate or a civil partnership certificate is produced, or even for a couple who may be cohabiting, evidence of a tenancy agreement, house ownership. The next criteria is that of the time period. Now, the legislation states that an application must be made within 6 months of the child's birth. Okay, there have been circumstances where the court has allowed an application for a parental order to proceed after that 6-month period has passed, but those have been in circumstances where there has been a reason for that delay and the court has found that to be justifiable. It certainly hasn't formed the norm in terms of applications that are being made. So the best advice that can be given is that applications for parental orders are made promptly and within 6 months of the child's birth. So in terms of the next criteria that the court likes to establish or has to establish, is that at the time of the making of the application and of the order, the child must be residing with the applicants. So essentially that the child's home is with the applicants, they are living with them. That is always the case after a surrogacy arrangement. However, that would be then confirmed by the court within its further inquiries. For example, by the parental order reporter, who I will go into further detail about in due course, just confirming that the child is living with the applicants and has their home with them. The next criteria is that the applicants, either one or both, must be domiciled in the UK. Okay, now domicile for these purposes is not just that the applicant lives in the UK. It has to be that there is a significant connection here in the UK and it is where their roots are and their allegiances and they intend to live. So in terms of each case, these are dealt with on case-by-case basis. But certainly if the court has any inquiries in relation to this, evidence is provided in the form of British passports and certificates of naturalisation, but also other evidence if the court wants to explore it further in terms of potentially having bank accounts here in the UK, owning properties in the UK, anything to establish the domicile element. The next criteria I have not encountered any difficulties with in any applications I've dealt with, but it is the age of the intended parents, and the court needs to establish that at the time of the making of the order, the applicants must have attained the age of 18. Okay, so we then turn to the issue of consent. So a fundamental part of the parental order application process is to obtain the consent of the surrogate or any other person who may be considered the other legal parent to the making of that parental order. Now, the provision itself states that the court must be satisfied that the woman who carries the child and any other person who is considered the parent of the child but is not one of the applicants have freely and with full understanding of what is involved agreed unconditionally to the making of the order. So if we break that down, essentially the court is looking at those three words, freely and unconditionally. So there's been no duress placed on the surrogate and that they have given their consent to the parental order with full understanding. It also forms part of this provision that the consent of the surrogate is only valid after a period of 6 weeks have passed since the child's birth. And essentially that is a cooling off period following the birth of the child. Now, evidence of the consent is obtained within the court process itself by the completion of acknowledgement forms once the applications have been received, but also through the completion of other more specific documentation, in which it sets out very clearly for the surrogate what the parental order is and what the effect of making the parental order will be on their status as parents. This will typically be witnessed by an independent person, so usually a notary, and that satisfies the court here in the UK that they've been given, had an explanation of what they're doing, and they're doing consenting with full understanding. If the surrogate does not speak English, then the court are going to want to ensure that any consent provided has been properly translated. So the effect of the parental order has been properly translated to the surrogate and they fully understand before they sign. Consent is not required necessarily if the surrogate cannot be found or is incapable, but the threshold is high for that, and evidence is going to have to be produced to the courts to justify why then to depart from obtaining consent. Okay, and then the final condition the court requires is in relation to payments. And the court must be satisfied that no money or other benefit other than for expenses reasonably incurred have been given or received by the applicants for or in consideration of the making of the order, any agreement for the providing of consent, for the handing over of the child to the applicants, or the making of arrangements with a view to the making of the order. And critically, that is unless authorised by the court. So unhelpfully, there is no definition within the law of what reasonable expenses are. And that is dealt with on a case-by-case basis. But it's worth noting that English law discourages, as Bianca has already explained, commercial surrogacy arrangements as a matter of public policy. And within the context of some international arrangements, there is a commercial compensatory element. That being said, there is now established case law where the court can and will retrospectively authorise the payments which have been made. And this is where it is considered that that is in the best interests of the child, which invariably it is. So when considering whether to authorise those payments, the court take into account a number of factors and look very closely at this. They will look at the engagement of the intended parents with the law in the jurisdiction where the child was born, so ensuring that they've complied with the laws over there. They will look at the engagement of the intended parents with the immigration authorities. They will look at the overall behaviour of the intended parents within the arrangement itself, and to ensure that they've acted responsibly. As well as this, the court will have a look at the overall level of payments which have been made in the context of the country in which the surrogacy arrangement took place, and also in the context of the surrogate's own circumstances. So on the basis that the court is satisfied, they will look at evidence such as the accounts of payments made to the surrogate. Sometimes receipts can be produced. It's helpful to have copies of things like the gestational carrier agreement, which can set out the timetable of payments. All of those issues and that evidence can be looked at by the courts. So, in addition to all of those above conditions and criteria, the court is going to be having regard to the overarching principle, which is the welfare of the child. That is going to be its paramount consideration within a parental order application. So the court will, throughout the application, have a wider eye on the welfare of the child, and not only now, but looking into the child's future and their lifelong welfare, and will ask itself, is the making of the order in the child's best interests? And it's worth noting that one of our most senior judges, Justice Headley, stated that it will only be in the clearest case of abuse of public policy that the court will be able to withhold an order, if otherwise welfare considerations support its making, which shows just what higher threshold the welfare has on these applications. So if we now turn to the court process itself, if the surrogacy arrangement takes place here in the UK, the process can be simpler and tends to take place in the lower family courts. However, if the surrogacy arrangement has taken place abroad, then the court process can become more complex and will be heard typically before a senior judge in the High Court. And the reason for that is because the court wants to keep an eye on these international arrangements and what is happening. Within the context of the court process itself, the court will usually appoint what is called a parental order reporter, and they will typically act as the eyes and ears of the court. And they may meet the surrogate or want to speak with the surrogate. They will certainly want to meet and speak with the intended parents and see them with their child. They will assess the criteria for applying for a parental order and also will be having regard to the welfare of the child and will be reporting back to the courts with their recommendations. Within the court process, there will, as I've said throughout, be consideration of the evidence that is needed to show that the criteria for a parental order have been met. And the court will look at the payments made for the arrangement. So, for example, copies of those trust accounts, copies of receipts and contracts. They will be looking closely at the consent of the surrogate and wanting to ensure that any consent has been sort of signed and executed properly. And also copies of pleadings that have taken place in the other jurisdiction to show that the intended parents have complied with the laws over there. Usually there are 2 court hearings for a parental order. However, sometimes there can be one, with the first hearing going ahead as paperwork, but usually 2. But once the parental order is granted, this is then sent to the General Registrar, who add this onto the Register of Parental Orders, and then a new birth certificate can be issued, naming the intended parents as the parents. And this will provide them, as Bianca has said, with legal parenthood and also parental responsibility. So how can agencies and clinics help with this process in the UK? Well, one of the main areas where they can help is if they have intended parents who come to see them at the very beginning of their journey, to signpost and recommend that they seek legal advice in the UK at the outset. And that's both in relation to immigration, so they can find out what process they have to undergo in terms of getting the travel documentation to travel back to the UK. And I know Barry is going to be speaking about that shortly, but also about the parental order application process itself, and to ensure that they are aware that that application will need to be made for them when they return to the UK. It can come as a surprise to some intended parents when they realise that they have another hurdle to cross. Another area where it can help is to ensure that the surrogate is also aware of her continued role in the process after the birth of the child, and in particular obtaining her consent after 6 weeks, and any support and liaising in this regard is also helpful. Also, keeping records and providing documents to assist in the process of that application for a parental order can be really helpful. Some intended parents don't always have all the documentation that are needed, or some, quite understandably, are completely overwhelmed by the amount of paperwork that they have. So it's also really helpful to be able to liaise to obtain that. But most fundamentally, in my view, the best way of helping is just being a point of contact. Within any surrogacy arrangement, there are lots of professionals involved, often in different jurisdictions, and therefore it's really helpful if we can all work together, hand in hand, to ensure a happy and swift journey for the family. So that was my whistle-stop tour of parental orders and the criteria. As I say, Bianca's indicated that we can answer any questions at the end, and we'll be happy to do so. So I will now hand over to Barry. Thank you.
Thank you very much indeed, Sarah. I'm just going to share my screen now as well. Okay. Great. Okay, so as Bianca and Sarah said, I'm a nationality and immigration lawyer, so I specialise in helping parents who've had international surrogacy arrangements. Don't really deal with parents who've had the surrogacy arrangements domestically, because hopefully there's no nationality and immigration issues arise. I'm just going to make a few preliminary points, which I think often come up just from speaking to a lot of intended parents who are going overseas in order to enter into a surrogacy arrangement. The first one is actually more about this seminar. Today, I'm just talking about British citizens in the main. There are, of course, other UK residents that might actually go overseas for an international surrogacy arrangement, and we will have usually, hopefully, solutions for them too. But today I'm focusing on when there's a British citizen parent or parents. To mirror what Bianca said at the beginning, and it's really important to get across to parents, that British nationality law does not take into account the other jurisdictions' definition of parents. And it's a really big point, because quite understandably, you go to the USA, they have a very well-regulated system that produces a birth certificate with both the British people's names on it. And, you know, well, surely, therefore, my child's a British citizen. Well, no, that birth certificate doesn't have any value in British nationality law. Britain has its rules and it will impose them. And that's what the parents really have to come to terms with. And it can be disappointing and frustrating, and understandably so. But it's the reality. So it's good to know that up front. As Sarah said, get your nationality and immigration advice up front. It's important because it stops any shocks coming down the line. You know what you're going to have to deal with. And it means also you can be realistic about the time scale, how long you're going to be in the other country after the birth, because depending on where you are and which route you're going down, it really makes a difference as how quickly you can come home to the UK. It also can be a positive to get that advice up front. And I'll just give you one example. As I go through this short talk, you will see that there can be quite a big difference between if you've got an unmarried surrogate mother and a married surrogate mother. Now, obviously, there's quite a lot of information out there on the internet, and I've come across some clients who've been so desperate to only have an unmarried surrogate mother that they've actually delayed their surrogacy journey by a few years because they didn't want to be matched with a married surrogate mother. And it's like, I don't understand why you've done this. I mean, I understand the reasoning, but we could have solved it with a married surrogate mother. And it's quite upsetting because it's like, really, you want to be paired with the surrogate mother that's right for you. You don't really want to be trying to fit your surrogate mother around British nationality law. Now, there are some circumstances where you really do want an unmarried surrogate mother, but they rarely are where you've got a British citizen parent. It's usually more where you've got a parent who's on a kind of temporary status in the UK. But that said, don't panic. There really is a solution. Sometimes the parents will be like, oh my God, my child's not a British citizen. This is a disaster. And it's like, no, it's not a disaster. We will usually find a way through. I'm not guaranteeing in every scenario, but when there's British parents, there is usually a solution. Right, so what are the basics? They're quite similar to the family law situation, but not exactly the same. Okay, so the first point is the British Nationality Act. That's what BNA stands for. There's no reason why anybody else would understand it, but BNA stands for the British Nationality Act. And it defines the mother. For the purposes of this act, a child's mother is the woman who gives birth to the child. That's it, full stop. You can't rebut that. It doesn't matter that the surrogate mother has no genetic connection with the child. She is the mother for British nationality law purposes, the woman who gives birth. And the second point is, so who is the father? Now, the Nationality Act talks about fathers, but is acknowledging within it that the other parent might be of the same sex. This is where it's slightly different to family law. The father is the husband or male civil partner at the time of the child's birth, not the treatment, the child's birth of the woman who gives birth to the child. And this is not rebuttable. So you have the basic facts which come up very, very commonly. If the surrogate mother is married to a man at the time of the child's birth, they are the parents for British nationality law purposes. So to give a very common example in my caseload, there was a US citizen surrogate mother. She is married to another US citizen man. they are the parents for nationality law purposes, and you cannot rebut that. Even though clearly they're not the parents, they're not the intended parents, they have no genetic connection, they are the parents. And even if that mother and the husband had were no longer living together and separated, and he really wasn't involved, he's married to her, he's still the father. Less commonly seen, but I think we will look at it here, is where we do borrow a bit of family law in order to deal with the nationality issues, is that if the surrogate mother was married to another woman at the time of the treatment, and that woman consented to it, she could potentially be the other parent, but that's rebuttable. And also, I've come across it once, if the surrogate mother was married at the time of the treatment and got divorced before the birth, her husband at the time of the treatment could possibly be, or her partner at the time of the treatment could be the partner. But I'm going to just say that quickly and just say, if you've got a surrogate mother who's married to a same-sex partner, or you've got a surrogate mother who gets divorced between treatment and birth, you really do need advice. It's quite niche, that bit. I think the point I really want to get across, which comes across commonly, is if the surrogate mother is married to a man at the time of the child's birth, then she and her husband are the nationality law parents. If the surrogate mother is completely unmarried, well, then other laws apply, and it's really what I'm going to go on to now. The legal father is the natural father, is the term used, but the biological father. So to summarize that, who are the parents in British nationality law? Parent 1 is the surrogate mother. Parent 2 is the surrogate mother's husband or male civil partner at time of birth, or the surrogate mother's spouse or civil partner at the time of treatment unless they did not consent, or when none of that, the surrogate mother is single, unmarried, the natural father. Now, this has consequences for which children are born British. So some children of a surrogacy arrangement abroad will be born British automatically. For that to happen, we have to have these conditions. The surrogate mother was not married or CP to a man at the time of the birth. So she was single at the time of the birth. And she was not married or CP to a person of any sex at the time of the treatment, unless that partner didn't consent. And the natural biological father is a British citizen otherwise than by descent. I'm going to go into that in 2 seconds. So essentially, to put that very simply, you will have a British child if the surrogate mother is unmarried and the biological dad is British. So if you have a British man who goes to Ukraine, and in that situation, and the surrogate mother is single, which is very common in Ukraine, the surrogate mother will be the first parent for British nationality law, but because she's single, the British father, the biological father, is the father for nationality law purposes. Now, you just have to be a little bit careful there, because as you've seen in bold, I've put the natural biological father is a British citizen otherwise than by descent, because we have two sorts of British citizenship, which don't really have any practical consequences apart from when you have a child born abroad. We have British citizens otherwise than by descent. Those are the people who were born in Britain or naturalised in Britain or registered as British citizens in Britain. They're otherwise than by descent, and their children born abroad can be British citizens automatically. We also have British citizens by descent, and that's people who themselves were born abroad and they were only British because they had a British mum or dad. And they are called British citizens by descent, and they cannot transmit automatically their citizenship to a child born abroad. So at the same time as thinking, is the surrogate mother single? And you think she is, this means I might have an automatically British child born abroad. You also have to just do a little bit of investigation how the natural father is himself a British citizen. Because if he himself was born abroad, then it is likely that he cannot transmit his British citizenship automatically to the child. There's still solutions, but it's probably not automatic. I'm not going to go into that further, but if he was born when his dad was in the army abroad, it's not the same. The problem we have with British nationality law, I should say as an aside, is that it's the nationality of a law of a country that had a big empire and then has spent decades trying to deny rights to people who actually were born in that empire, and adding in a load of gender discrimination, and it really has made it quite complicated. That we're getting there at making it make some sense, but it hasn't quite got there yet. Right, so if you've got an unmarried surrogate mother and a British father who's the biological father and can pass on his citizenship, well, then you're off. You're going to apply for a passport. It's done. And that is a common situation in, say, Ukraine, as I say. I find that in America, it's much more common that the surrogate mother is married. Not always, but it's much more common. So in that situation, because the surrogate mother is married, and so let's assume she's married to a man, she and her husband are the parents for nationality law purposes. So you don't have a British child. And so you think, well, I don't have a British child. We're British, or I'm British. How are we going to make that child British? Because obviously that's a very desirable thing. There are two solutions. The first one is via parental orders. And the second one is through registration under the British Nationality Act. Now, first of all, I'm going to deal with parental orders. If you obtain a parental order in the UK court, the child is a British citizen from the date of the parental order if one of the parents is British. Full stop. It's great. So you go along to Sarah, she sorts out your parental order for you, sends Bianca along to the court just to sort it out as well. And from the date it's issued, the child will be a British citizen. And so it's a great solution, though many parents don't rely on that alone. They will do it, but they often want to have their child British before then, and I'm going to go on to that. But the parental order solution, so if you get a parental order and one of the parents is British, then you will have a British child at the time of the parental order. And sometimes for that reason, sometimes I'm acting for parents who are not yet British, but there's a parental order looming in the distance. It's like, let's try and make you British yourselves before that is done, so that actually your child will be automatically British. So that's one solution. The second solution is that you apply to the Home Office, which is the part of the government that deals with nationality issues, to ask that your child become a British citizen. Now, this is usually a discretionary application. You're saying to this body, my child isn't British, please can you make my child British? And then the Home Office decide whether they will do that. Now, and so it really is, the law is, it's pretty much up to the Home Secretary, who at the moment is Priti Patel. She's very beloved of us immigration and nationality lawyers here in the UK. Obviously, they don't really do it on such a discretionary basis. They have policies in place. And if you meet one of their policies, then they will register your child as a British citizen. Now, before I just quickly look at the policies, I want to say something it's really important, because this is quite difficult for the people to get their head around, for intended parents to get their head around. When we register a child, and as I'll explain in a second, we usually do that before the parental order. We are in no way changing the legal parentage. We might obtain British citizenship for the child, but the family law principles as who is the parent still apply. And so these parents still need a parental order. And that can be very hard for a parent to understand. So, well, hang on a second, you said I wasn't the parent, but now my child is British because I'm British, but I'm still not the parent. And the answer is yes, you're still not the parent. You still need the parental order. We've just done a little trick in nationality law, for reasons I'm going to go on to make your child British ahead of the parental order. Right, so what do the policies say? They say that where there's a man who's the biological father of the child, but he can't meet the definition of father, because the surrogate mother's married, well, you register in those circumstances. Where the man's not the biological father, they'll usually register in those circumstances. And where there's a woman, we don't care whether she's the biological mother or not, they'll usually register in those circumstances. They then go on to actually ask for loads of criteria, but essentially, we usually have, if we've got a British citizen parent, biological, non-biological, we can usually register them as British citizens. The only circumstance where that wouldn't happen, and it's quite complicated, so I don't want to go too much into it, is if you've got a British parent by descent who has never lived in the UK for a period of 3 years at any point, that might be a problem. But in all other situations, we can usually register as British if we've got a British parent. Now, why would you bother going through a registration process and not just wait for the parental order? Because as you can see, the parental order is like, if you get one, you're British, your child's British. It's a nice, simple solution. But why'd you come to me and go through this registration process, apart from the fact that I'm really nice, you like to chat to me, you know, why not spend more legal fees on an already quite expensive journey? Now, seriously, the reason is that they're manifold, but I'm just going to go through some of the reasons why you do it. The first is you might not be intending to get a parental order. Now, that's not a good idea for people who are living in the United Kingdom. And I always say to people, really, that's not a good idea. But sometimes you come across, for instance, there's a British citizen parent living in the United States. They're the legal parents in the US. They have no plans to ever move to the United Kingdom. They are happy with parentage established in the United States. So they're not going to get a parental order, but they still want a British child. The second one is, as you'll see, registration is actually available to parents without a genetic connection. So whereas you can't get a parental order without a genetic connection, you can register your child as British. You still need a family lawyer, because that family lawyer is still going to have to come up with some clever court order that I can see Sarah and Bianca thinking about it now. What would they do to give you some sort of parental responsibility light on this child? But that's another reason you might do it. The biggest reason it actually happens is speed. We can usually have a child registered within about 2 to 3 months of the birth. Whereas sadly, as far as I can see in the courts of England and Wales, at least, I'm not sure about Scotland at the moment and Northern Ireland, but in the courts of England and Wales, the parental orders seem to be taking up to about at least a year. Can you nod if that's correct, Sarah? It seems to be about that long. And for this reason, parents want to get their child British up front for the other reasons I've given, which is like they need them to be British to get them back to the UK in some circumstances. They need them to be British to be eligible for the full gambit of the NHS, the National Health Service. Everybody can use GPs or base level doctors, but not the higher level doctors. And just a way of ensuring lawful status. They need some status in the UK. There are other parts of immigration law that are visa solutions. So I've just put them there just to highlight them. But because they're very rarely used by British parents, because British parents tend to rely on nationality law, I'm not going to go into them. And I just want to make some very final points. Parents often want to come home very quickly, but there's a big difference between where you have your surrogacy arrangement. And I'm going to use the example of US and Ukraine again, because obviously I use it quite a lot. In America, the children are born US citizens and can get US passports. Also, US citizens can just get on a plane and come to the UK. Now, strictly speaking, in immigration law, that's not right. You should only come to the UK without a visa as a US citizen if you're coming as a visitor. But the truth is, in practice, if you're a small baby and you've got a US passport, immigration lets you in. So these babies who have US passports, they can come home quite quickly. But if you're born in a country where you're effectively status, or in a country where you can't even get on a plane without a visa to come to Britain, well, then you're going to have to sort something out while you're in that country. And that can make a big difference as to how quickly you're going to get home. So if you're going to have a baby born of surrogacy in, say, the United States, or if in Canada, countries where you can get a passport and then come to Britain without a visa, you're probably going to be home relatively quickly. If you're in other countries, it's probably going to be longer. But there are other benefits to other countries, you know, and I'm not going into that, but it's just timing can be key. Just to say that there are solutions to non-British parents. And finally, to bring us in on time, will nationality law change? Well, we thought it was going to, because actually the High Court has said this definition of a father is not human rights compliant. Really, the biological father should be somehow recognised automatically. We thought that would change, but in fact, the Home Office are dealing with it in a very poor way. They're not going to change the law. Actually, they're going to try and make it a little bit easier to register, but not much. I just on that point, I'm very critical of the British Home Office, but actually, in surrogacy point matters, it's my favourite part of the Home Office. They are very good, and they are not looking to put up a barrier. They're actually looking to facilitate. They understand how the law works, and they're trying to facilitate these issues. So they're very good. The British Passport Office, I don't like as much, but the Home Office, they're good. Right, I'm going to bring it to an end there because I have to head off at 6:15. So if people want to put any questions in the chat, I will actually answer any immigration nationality law ones, and Sarah and Bianca can answer any family law ones. So ask away if you'd like to. Do you have any questions, Bianca or Sarah?
Sarah.
Sorry, just how long roughly is it taking to get the documentation to sort of come back from Ukraine then currently?
I tend to find that the agencies I've worked with in Ukraine, they're very efficient, and so the problem doesn't really lie with them, because they're usually getting the stuff together quite quickly. And as I say, most surrogate mothers I find, it's just my experience, though I can't be certain, are unmarried. So if you've got a British biological father who's British, otherwise by descent, you're going directly to a passport application. The problem we have is the passport office can go very slowly and can take up to 4 months for a passport. Now, the ones I've been dealing with, we shout or scream, and in some circumstances have managed to get emergency travel documents. But when parents are in Ukraine, I'm using Ukraine, it's other countries as well, but it's a good example because there's obviously a lot of British parents go to Ukraine. I am estimating it could be up to 4 months. And I would then consider with them whether there's a visa option that would be more quicker. But it becomes quite complicated because these children are not Ukrainian either. They're usually born stateless. Sorry, they're born British and they're not Ukrainians. Sorry, they're usually the ones that are born British. They don't have another passport that we can put a visa in, and that creates all its sorts of problems. Right, there's a question now which you two can answer. Which version of a US birth certificate is most helpful for the parental order? We have the option of getting one with the surrogate and genetic father, just the genetic father, and the final version with both intended parents. Kelly, can you just put in which state that is? Because that's really fascinating. Minnesota. That's so speedy. Bianca, Sarah?
Yeah, I mean, I think that's probably a personal preference. I don't think it makes a difference for the parental order application, because at the end of the day, you're going to be showing that you're the intended parents, and the legal parents, if your surrogate is married, are the legal parents before the parental order is made. So, I mean, I think that decision is if you want the Minnesota birth certificate to reflect yourselves as the parents, then I think that's absolutely fine. It's not going to make a difference in this jurisdiction when you go through the process of getting the parental order. Sarah, do you agree?
Yeah, I agree. And actually, I had a case I was dealing with where actually we had copies of all of those and put them all into the court bundle. So yeah,
we sometimes do that, just throw everything but the kitchen sink. But yes, I mean, as Sarah referred to before, that's where also getting in the proceedings that take place in that jurisdiction is so important. Not because it's recognized in this jurisdiction, but then it shows the intention of everyone involved. It shows that the proper format has been utilized. I mean, the other thing to note is that in this jurisdiction, we don't enforce surrogacy arrangements. So people will have surrogacy contracts or surrogacy arrangements that they perhaps entered into themselves or drafted themselves, but you wouldn't be able to enforce that in a court of law. That being said, if they do go to a jurisdiction where people use surrogacy contracts, that can still be incredibly helpful when applying for the parental order, because it doesn't stand in for anything, or doesn't stand in, for example, for the surrogate mother's consent, but it does just show what the journey was, what everyone's intentions were, and can be incredibly helpful, especially where it sets out the payments made and what those payments were utilized for, because what the court really likes to see is as much information as possible to show that the criteria under Section 54 that Sarah took you through is met. So I see another
so from a nationality perspective, I usually want to crack on quite quickly. So my answer is usually I need a birth certificate, even though it's not determinative of the nationality issue. I need the birth certificate to make an application. So usually I'd be like, well, give me if I'm applying to register, I'd say, give me the first one that comes. And if another one comes later, fine. But really, I just want, I would probably think about it from a speed perspective. Fiona Duffy's asked, if a child is born through surrogacy in the UK, can that child get a British passport immediately, or will a passport only be issued after a parental order is made? If so, does that mean the child cannot leave the UK in the interim? Fiona, it would very much depend on the status of the surrogate mother and any husband or etc. So if we had a surrogate mother who is British or has indefinite leave to remain, is a permanent resident, well, then she's considered the mother, but because she's having a child here in the UK, then that child is automatically British. Oh, you've answered here, she's British married. Yes, so Fiona, if we've got a British surrogate mother and she has a baby in the UK, well, then that baby is British through her, as opposed to the intended parents. But the child doesn't care, because basically it's the British citizenship that matters, and that child will be born a British citizen otherwise than by descent. So you probably would have to explain it to the passport office what's going on. I would definitely explain it, because the passport form will ask, is there a surrogacy arrangement? You need to tell us. But you just explain that these are all the people involved, but the birth mother is this person, and you can get the clinic to say that. And she's British, here's proof of her British citizenship. The child was born here, so the child is a British citizen. So the child is British and apply for a passport. Thanks for clarification, Fiona, it made it easier to answer. Okay.
I mean, one thing intended parents should be aware of is when you make the application for a parental order, obviously you don't have, as we've said, legal parenthood until such time as that order is granted. However, as an interim measure, what the court will often do is make what's called a child arrangements order. Now, that's a family law order that says the child lives with the intended parents, and also gives the intended parents, or can give the intended parents, parental responsibility. So even whilst they wait for that final order, they still will be able to make those decisions about, for example, education, medical care, and so on. Though I do have to say that in practice, I'm not sure how many people actually ask for proof of a parent's parental responsibility. It's just sort of assumed if you come in with presenting your child as a parent, but it's a good thing to have in the background in case there are any issues.
And then on the point that Fiona raised as well, it just to always check. It has happened to me. Always just check that the international surrogate mother doesn't happen to be British. Because I have had a situation where I've got quite far through and said, can I have a copy of the surrogate mother's ID? And they've sent me through the British passport showing that she was born in Scotland. Where I had a bit of egg on my face. It was like, I don't think I did actually check this, did I? And now I always check. Just so happen that the mother in America isn't actually a British citizen, otherwise by descent. It does happen. People move. So it was quite good, because it's all potentially a tricky one, but it was surprising.
I mean, I don't know what it's like in the immigration tribunals, Barry, but like, even though we've set out all this criteria under Section 54, the judges who deal with international surrogacy arrangements in the High Court will use very creative interpretations of the law in order to get around those criteria if necessary. So things like, Sarah alluded to earlier, well, you have to be living with the child. We've obviously had circumstances where the intended parents, for example, get divorced before the parental order is made. And the court in those circumstances has what we call read down the law to be able to make the parental order, even though the criteria is not met, because it's in the best interest of the child. So most of the criteria, when the consent needs to be given and so on, the court will get around. I mean, the sacrosanct ones are the ones like the surrogate mother has to give fully informed consent, but otherwise the court has been very good at dealing with the limits to our statutory law. Is that similar in immigration, or is it much more inflexible?
No, it's well, in terms of is the person British, it's inflexible. If the passport office does not accept this child as British, it will not be given a British passport, full stop. And actually they can be quite tricky. But what we have is this backup of registration and a Home Office that on a discretionary basis is much more flexible. So we've got a slightly different, it's not really adversarial in a way or contentious. So what we have is if there's a non-acceptance of Britishness, well, we have a backup that we actually say, well, okay, let's make the child British. And I have in the past, not very often, sometimes if there's doubt, I've actually gone to the Home Office registration section first, say, I want to register this child, but if you think this child's British already, then just tell me, because they will do that. And it's actually sometimes better than going directly to the passport office. But yeah, so they won't read down nationality law, no, but they will let us register when nationality law should be, on the basis of what nationality law should be if it was doing what it really should do and wasn't subject to these weird historical anomalies.
Now, I don't see any more questions in the chat room. Just to let everyone know, I think this recording will be available after the fact. Not suggesting you want to rewatch it, but just in case you missed it.
I'll watch it a couple of times later, actually. Just like,
well, I mean, yeah, no comment, Barry. But again, if anyone has any questions, you're always welcome to contact. Well, I should probably speak for myself. I'm always happy for people to contact me through my chambers, which is just clarks@coramchambers.co.uk. I'll leave that to Sarah and Barry if they're happy for that as well. But this is an area of law that, and look, Barry's already put it in the chat. I'll do that too. This is an area of law that all three of us, I think, are incredibly passionate about and do a lot of work around, both on a paid and pro bono basis. And so I always welcome, especially the more, legally challenging questions that arise. So please feel free to get in touch.
Yes, I'm always up for a quick chat about things. I like the sound of my own voice. Okay, I must run.
You must.
Thank you so much to Coram for arranging this. It's always really good for me to, as an attendee as well, to listen to the family law stuff, because even though I never advise on it, it's good for me to have this kind of refresher to actually understand what's going on. So I really appreciate it. Thank you both.